Hey, I'm back at it. This is Kenneth Plaisance, Kenneth Michael Plaisance. Um, I'm chopping in the country again. Back again. I'm back. You'll be back. Anyway, so there's a garden that my friend had done, and this what came out. You know, this is what came out. Little bell peppers. Nice smell to her. We got some squash, some dill pickles. I think she must have about a month ago, and this came out of the garden, man. And that's what I think we ought to be doing now, because we really don't know what's going to happen. We're not out the woods with this COVID virus pandemic. I think there was 1,800 cases in Texas, I think. As of yesterday, more cases. So we're not out of the woods now. But I think that again, it's about nourishment. It's about good food. And it's about the seasonings that go into the food. And then we've got some tomatoes, tomato plant right next to me. I don't know if I can show you, but yeah, tomato plant. Got a little tomato here. Yeah, so just in your backyard, man, just like 4 rows of squash, dill pickles, cucumbers, bell peppers. She's got some other stuff. She's got green onions, tomatoes. She says she's gonna have an abundance of tomatoes, and right across I see sugar cane. So I'm in the thick of the country. Goodness gracious, yeah. But it's healthy. I think it's healthy, and it's good to have somebody in the country that can show you how to kind of like cook in the. I mean, not cook, but like garden in the backyard or in pots and plants. So again, a squash, some cucumbers, little small bell peppers. That's cool. I came out the ground, man. They got an orange squash. I don't know about that one, but we're gonna see. We're gonna see what happens. Anyway, we're gonna get back to chopping, and our subject today is gonna be it's gonna be workers' compensation. I'm an attorney as well, and I got a master's in employment law, which includes discrimination, workers' comp, civil service, federal, state, and local city civil service matters, almost like union stuff. And then I did the gambit in terms of employment law. So I know it very well. I've got 30 years into the game. Believe it or not, I made it this far, Anyway, like I said, we got a master's in employment law, which includes workers' comp. So we're going to talk about, as I chop, we're going to talk about the COVID virus and those things that may affect how does it apply to workers' compensation statute. We're gonna get into the general rule, and then we're gonna go with some other stuff, and then we're gonna conclude with how you do it. And I'm a plaintiff's attorney. I used to work on the other side in defense, insurance defense, and also I work for the city attorney's office in workers' comp and civil service matters. So I know it. So I was on the defense side first, and so most of the claims adjusters that I know, I used to work as a claims adjuster as well for two major insurance companies, and I sold insurance for another insurance company. So I know insurance very well, like the back of my hand, So that's what you're looking for, somebody who's got experience on the end of settlement and evaluating claims, and then you want somebody who knows how to litigate. In particular, right now, we're going to talk about workers' compensation claims. All right, so let's get into it. All right, so we got our stuff here. All right, we got an onion here. We got our parsley. All right, let me just take a little bit off, and yeah. we got some celery. Just washed them. Get a couple of these, maybe 3 of these. And then we got the big bell pepper. I think I'm gonna take them 2 little ones. I want to see how they work out. We're gonna work these 2 out. We're gonna work the 2 little ones next to the big boy. The big boy is right, yeah, right here. I'm telling where I'm coming from. New Orleans, you know. So we got all kind of sayings in right here, you know, which means right here. You know, just little sayings like that. It's again, you know, New Orleans kind of slang. But I'm kind of digging on these cucumbers, man. Just like, you know, pickles and stuff. I guess we'll put that in a salad. Like I'm saying, we gotta make sure our families are eating well, and you know, do a garden in the background. I know y'all probably don't have the time, but now y'all do, because now it's shifting over towards working at home, and so what you want to do is to you know, do that. Do a garden. You know, do a garden in the backyard. It shouldn't take that long, and that's all you gotta do is put the seeds in the ground. Now she made 3 or 4 rows, right? No, I think no, about 10 rows. And so she put green beans. She put the bell peppers. She's got green onions. You know, we call them green onions, shallots or whatever. I call them green onions. She's got sunflower seeds, and she's got some other stuff as well. You know, so that's where I think we're gonna have to be at. You know, because it might have a food shortage. So you're gonna have to try to do this thing anyway. If you're at home, you know, and I know you got your kids and so forth, and you might not have no time to do it, but maybe get them out there and have them learn how to do a garden, how to cook, you know, because they're gonna be the future. You got to be the future, huh? Come on. And they gotta learn how to do that. So anyway, where's my towel at? Yeah. All right, so here we go. We're gonna do this here. We're gonna do this here. All right, here we go. But all right, so we're getting back on workers' comp. Now, workers' comp is a strange law, strange beast, and the Workers Compensation Statute was drafted and enacted to save. Well, let's put it this way. It's supposed to be a trade-off. Why the Workers' Compensation Statute was enacted. That is, the employee, well, the employer is to pay the employee 2/3 of his average weekly wage. So you take 4 weeks of what your average weekly wage is, and you divide it by 4, and that's your average weekly wage, and 2/3 of that is what you are entitled to. But there's a cap as well, so you gotta whatever the cap is. So if you're making like $2,000 a week, then there's a cap like of 1,000 or something like that, 600 to 800 in terms of a cap. Then all your medicals are supposed to be paid, and all your medical treatment that's reasonable and necessary is supposed to be paid. That goes for testing, MRIs, CAT scans, EKGs. Well, not so much EKGs, but they're going to try to rule out some things if you're having problems in the heart area or the left arm, if it's got an injury. Anyway, yeah. So everything that is reasonable and necessary, and that's related to or correlated to the accident. So okay, this is how we're gonna get into it. So kind of like doing my garlic first, you know, and garlic is kind of, you know, I've got to have a lot of garlic in my food. I mean, that's just something that you gotta have. So move some of this stuff. Gotta move it so I can have some. I'm kind of excited about my little, you know, little bell pepper, man. You know, came out of the ground. All you had to do was put a seed in the ground, and you know, came through. You know. But anyway, so all right, workers' comp. So, so of course, you know, you got to have a sharp knife when you're cutting, chopping. I kind of like chop. It's called preparation. So I'm doing two things at one time. So, pray for me that I don't cut my fingers off. But I think I'm skilled enough. I got skills. All right, so here we go. Office Workers Comp, the Workers Compensation Statute. And so the statute says that if you're injured or you have an illness, so it does say illness now, and we're going to try to correlate it, and we're going to try to talk about what ramifications that the COVID virus has with respect to that, So it's kind of weird that this is all happening. Now I'm talking about, those people that were injured on the job or have the illness, such as nurses, doctors, our first responders and so forth. If you're on the job and you get this illness, are you entitled to workers' compensation? So, and I think you are, because it says an accident or illness. But anyway, for the most part, it's an accident. So if you're on a job and you fall and you break your leg, that's an accident and it's on a job. So then the Workers' Compensation Statute says that you shall get wage benefits, 2/3 of your wage loss, and also all your medicals, reasonable and necessary, and vocational rehabilitation if needed. So if you a carpenter or whatever, and you have a herniated disc or you have a broken arm or whatever, you might be temporarily and totally disabled. And so the thing is that you shall get those things. Now, there's another part of the statute on how you get your wage losses paid. Now, they're going to pay you your medicals, but they're going to try to trick you out of, or dupe you out of, I guess. I like to call it.
For 150 years, Vaseline has been helping heal dry skin.
I've got
now more than ever.
Something in the background.
Vaseline is donated to medical workers on the front lines.
So, all right, so what we're doing now is
we will get through this. Vaseline.
Vaseline is good.
And support Operation Homefront's mission to provide military families with critical financial assistance.
So we're getting back to
the lives of vets and help Cheerios donate up to $250,000 to Operation Homefront. Buy specially marked boxes of Cheerios. Enter the code in the box at CheeriosGives.com.
Getting back to the workers' compensation. What are you entitled to? And you're entitled to all your wages, wage loss up to 2/3 of your wage loss. And that's kind of a trade-off. And the trade-off I was telling you about, that the employee is supposed to get your wage losses and also your all your medicals, reasonable and necessary. Now, the trade-off is that that they don't get sued. The employee is not going to sue the employee for pain and suffering. So they did away with the pain and suffering, and you get 2/3 of your wage loss, and you get all your medicals, reasonable and necessary. And so that's a general rule, and it's supposed to be liberally construed in favor of the claimant. Now, what does that mean? That means that the claimant or the workers' compensation employee is supposed to get the breaks, because they're the ones who are getting hurt, and it shouldn't be, conservatively construed in favor of the employer. So So it's kind of weird. But what they did, all right, they made a statute and they said all these things about, oh, it's a great statute. It's going to cut down on pain and suffering and personal injury against the employer. And in turn, the employee will get all this wage. And it sounds good, but they got a statute. They got some cases out there that suggest that you've got to prove clear and convincingly that you're entitled to workers' compensation, wage loss. You're entitled. You got to put. That's a higher standard. There's standards of how do you prove something. So there's a couple of standards. There's by preponderance of the evidence, reasonable doubt, and then there's clear and convincing evidence. And I think there's another one. But clear and convincing evidence is the highest standard in terms of proof. And so that's how they get you. And So if you're injured on the job, get you an attorney, a plaintiff's attorney that knows what they're doing, and get to a medical doctor that you know, and also you're entitled to have a medical doctor of your choice and an orthopedic specialist in your choice and so that's what you want to go, because it's been my experience, and of course that somebody's going to take advantage of the situation. So what's happening is that if you go to your own doctor, then you can prove that you're unable to work, by unable to work slip until further notice. It's called temporary total disability, unable to work slip. You got to get that, and you got to give that to your supervisor or the foreman on the job, or the business or the human resource department. I would go in and fax it, email it, and then make sure that they get it, so they know that you're unable to work before they do it. See, most of the companies, they'll take you to their doctor, and most of their doctors is company doctors, so they get paid by the company, right? So they got to keep their their business going. So they got to say that you can work light duty, and once they do that first, and they say that you can go back to work, and usually the body heals itself, they say, to tell you, and you might have a tingling underneath your arm, or your back is all messed up, and they'll say, well, at this junction we're gonna take an X-ray. We ain't gonna take too many, like an MRI report or imaging, from an MRI. Man, it's raining out in the country. Okay, I'm getting some little rain this time, but anyway, so that's me in the background, and we did that back in 2003 before the storm, Hurricane Katrina. And that's a lovely lady. Anyway, as you listen, all right, I'm getting off the subject. All right, so here we go. All right, we're getting back to how does COVID virus affect that? Now, it says if you get an injury, it ain't a personal injury, because the statute was designed to make that statute the only remedy of an injury on the job. So that means that you can't sue for personal injury. So it's an injury on the job injury, or illness. Yeah, it says illness. It does say illness. So I think it does apply to the COVID virus, and especially at the hospital or a nurse or something like that. So, but you got to have your own doctor. You got to have a doctor to say that you're unable to work as a result of this injury or this illness. And most I've seen some cases that post-traumatic stress disorder was compensable underneath the Workers Compensation Statute. And they talked about, the last one I read, it said that they allow workers' compensation benefits for a bank teller that was robbed, up front. And so she freaked out, yes. Somebody put a gun in front of you and say, give me all your money. But of course, that's post-traumatic stress disorder. So, but in this say we see a nurse, and the nurse sees all these deaths in the hospital and so forth, and the first responders. I mean, that's post-traumatic stress disorder by itself, consoling the parents or consoling the loved ones of a person that died of COVID. So are you entitled to it? I think you are, but again, you've got to prove it by clear and convincing evidence, which is a higher standard. So you go to the hospital. I don't know, you can go to the hospital or you go to your own doctor, and they'll determine. And if they give you unable to work slip, you kind of got most of it going. Now, if you go to their doctor is going to say, because they're being paid, the company doctor, they're being paid by the company, they're going to say, oh no, ain't nothing wrong with her. There ain't nothing wrong with him. All right, here we go. Yeah, so So how you prove it? And that's the whole deal. If you can prove it, and if you get your own doctor to do it first, then you're above the game. Now, if you get their doctors to say that you can go back to work and ain't nothing wrong with you, then you gotta that's an obstacle you gotta hurdle over. Proving it by clear and convincing evidence. Post-traumatic disorder, of course, I just talked about that, and then an illness. So I think you got to get somebody who knows what they're talking about. You got to get an attorney who knows this area very well, and that's proactive in it. Not just waiting on something to happen. You got to be proactive in terms of and you got to do volume, because I used to do it on a regular basis, and you have to have volume to make some money as an attorney. So, all right, this is my other song. It's called "Love Me Like Africa." My younger years. So, anyway, the reason why love me like Africa with your golden. All right, I'm getting off the subject. All right, so and I'm published in the Southern Second, which is a kind of a feat that you want to do, you want to have. So I'm 613 Southern Second. I forgot the last three numbers, but just look in that and look for my name, and I'm in there. And I talk about supplemental earnings benefits. So even if you don't get your temporary total disability or permanent, because you didn't prove that you were injured, or your injuries dictates that you're unable to work or totally disabled in terms of temporary total disability, partial permanent disability, and then total permanent disability. You got to prove that by clear and convincing evidence. But supplemental earnings benefits, that means that you are entitled to supplemental earnings as a result of the accident. And you only have to prove that by a preponderance of the evidence. So that's one that you might want to do, but it's a little tricky. There's a Tyson case that says that if they don't prove that you can go back to work, then it's a zero balance. So if you get your average weekly wages without any deductions, But if they get a vocational rehabilitation person to come in, and they'll say, and the company the company pays this vocational rehabilitation person, and they might say, well, he can go or she can go and do drafting, or go back to work to do this. So then they'll subtract something at it. They'll subtract that. How much does that job will pay, and they'll subtract it from your average weekly wages. But it gets kind of tricky, so you need to know somebody. An attorney need to know what they're doing. They really do. I mean, you gotta. And I used to work at the city attorney's office in workers' comp, so that's where I learned it from. And then I did it for the first couple of years when I had my own practice, when I started my own practice. Anyway, so here we go. So what are you entitled to if they don't pay your benefits? Now they're supposed to. I mean, it's supposed to be liberally construed in favor of the claimant or the employee. That's why the statute was done. But they do these tricks, and it's called labor cost. It's called cost analysis. It's saying, well, if we delay the payment of a wage loss, then we can frustrate him, and then we'll settle for something less. And so that's what goes on in this area, and that's kind of sad, Or they're forcing you to file for Social Security benefits and make you a ward of the state, and therefore they don't have to pay the workers' compensation benefits. The insurance company, or now they're doing it a lot. Well, they've been doing it. It's called a TPA, a third-party administrator. And so, and the thing with them, there's no regulator. With insurance companies, it's the insurance commissioner. You can say, hey, look, these guys are not paying, paying these people when there's a statute that says that you have to pay, shall pay, But a TPA or a third-party administrator, they don't have that. The only way you can sue them is say it's an unfair and deceptive trade practice in the areas of benefits, you know. So it's a tricky thing that, and that might be a little hard to prove, but I think it's a possibility. And I, of course, you know, I'm always trying to stretch the law or get to a point where I can get something from my client. Anyway, all right, moving along. All right, so if they don't pay you for a year, and then they're trying to force you to go to unemployment or Social Security benefits or whatever, you know. So they don't have to pay. That's crazy, huh? It's frustrating when you can't pay your bills. All right, so COVID virus, I think it is it applies to the statute, Louisiana Workers Compensation Statute. I also could practice in Texas as well. I got to read more about whether it applies in Texas, but in Louisiana, I think it does. It says accident and illness, and then it's post-traumatic stress disorder, and that is an accident and illness as well. So I think you have a chance, but you've got to have a doctor, a reputable doctor, to say that you're unable to work, and that's cool, and that's the game plan right there. That unable to work slip, temporary total disability slip, is so important. But you need an attorney. You can't go at that. I mean, a lot of people are smart and they can do it. They can read the statutes and so forth and so on. But you got to have somebody who knows it, such as me. You know. But anyway, all right. Oh yeah. If they don't pay you, there's a part of the statutes that says that if they're arbitrary and capricious, that is bad faith in paying, then you get attorney's fees and excuse me, talking too much, huh? All right, you can't see that. Yeah, it's a pink drink. Anyway, so arbitrary and capricious, and I think you can get attorney's fees plus penalties. But again, you got to prove that, and if you got to prove it each time you send a letter and they don't pay it, and then you got to present that to the judge, and hopefully you get a good judge. I mean, sometimes they got the newer judges don't know as much, you know, and then it depends. So hopefully you'll spin the wheel and get a good judge, because there's no jury. That's another thing that they took away from workers' comp. There's no jury. There's no. I think before the 1990s, you know, you had a jury trial with workers' comp, and and I passed the ball about that time. and of course, I think they have a complex about it. Let's put it that way. It came up with tort reform and workers' compensation reform right when I passed the bar exam. Everybody else made all the money in the 80s, and now in the 90s, you know, you couldn't make any money, you know. So, but anyway, so you're entitled to attorney's fees. You got to prove, I think by clear and convincing evidence, again, that they were arbitrary and capricious, which means bad faith, which means that they were like doing trickery and chicanery on failing to pay your workers' compensation benefits. All right. Now, the only way you can sue for personal injury in a workers' compensation situation or accident injury, if you were battered on the job. All right, and that's a personal injury, and that's a battery, which is a personal injury. If somebody did it intentionally, then you can sue for personal injury, pain and suffering and so forth. Or if a third party comes in and then they do something, then you can sue the third party, not the third party administrator, but a third party. Let's say there was another contractor on the job that didn't do their work, a subcontractor's on the job, and they didn't do their work, then and you were hurt because of their negligence, then you can sue that company. So that's the only exception to the rule that it's the remedy is only workers' comp on the job injury. I think if that's about it. I think I touched upon everything. Give us a call. Hit the like button and the subscribe button. I think I don't say that too much. And that's Kenneth Plaisance, attorney at law. Been doing it for a long time, since the 90s. 1991. 1989. Dang, I'm telling my age. I'm not gonna tell you my age. Anyway, you can do the number, do the math. Anyway, I think I touched upon everything. Give us a call. I'm at 504-905-1888. Email me at kplaws88@gmail. And I'll be glad to take your case, but you got to prove. You got to go to a doctor. You can't go to the company doctor and expect them to help you out with that wage loss. Anyway, Kenneth Plaisance signing off. I'm gonna do some more chopping and maybe get into some civil service matters. Talk about civil service and discrimination. I've done discrimination cases, civil service matters. I've taken cases. I could practice in Louisiana, in the United States Supreme Court, in the U.S. federal court, which is the highest court in the land and the second highest court in the land. So I've been doing my thing, my thing, Anyway, you want somebody who cares about the law and cares about people. All right, like I said, hit the like button, subscribe, get a consultation with me, and we'll go from there, But I think that the COVID virus is compensable underneath the Workers Compensation Statute, both the illness and both post-traumatic stress disorder. Give me a call back. Give me a call back. Email me. Try to get in contact with me. Be glad to help. You can't have the company doctor say that there's nothing wrong with you. Then you're gonna be out of how to prove it. It's gonna be proven. It's gonna be a high hurdle, obstacle. Anyway, give me a call back. Appreciate it. KP signing off. Hit the like button and the subscribe button. Thank you.